sewage. So we can have clean debates.
I didn't know you wanted to do it earlier.
Well, all right. So now we're going to move into the audience participation part of our show. And I want to thank you very much for those of you who submitted some questions. And I particularly want to appreciate your penmanship. Because if I now flub this question, it will be entirely my fault. So this is going to be a question for all four of you, and let's start with Judge Inman. When should the Supreme Court bypass review of the Court of Appeals? What would multiple bypasses of the Court of Appeals signal about the role of the Court of Appeals? Directed to a judge on the Court of Appeals.
Absolutely, absolutely. Well, the Supreme Court has the discretion to bypass the Court of Appeals. It doesn't do it that often. The circumstances in which I think or the factors that would perhaps justify the Supreme Court doing that, if there were a question of tremendous importance that also was on an extremely short timeline, where you're going to have circumstances that irreparable harm is going to be done to one side or the other if this isn't resolved in the next 6 months. That would be a reason that the Supreme Court could bypass the Court of Appeals. Of course, every litigant probably thinks their case needs to be decided in the next 6 months. So it's really up to the justices on the Supreme Court to think about that. I think that when the Supreme Court bypasses many cases and takes them from the Court of Appeals, it suggests to me that the Supreme Court doesn't have enough of a workload because they're taking more cases. It suggests to me that the Supreme Court doesn't think that the case could be resolved at the Court of Appeals, and I don't think that's a good enough reason to bypass the Court of Appeals. But I do think when you have some tremendously important, especially state constitutional issues or other issues that are on a short time frame, I think of election law, because we're going to have an election, and if there's a dispute and you need to get it resolved before the election, that would be a reason to do it more quickly. Business court cases used to come to the Court of Appeals. I miss those cases. They now go to the Supreme Court because of our legislature. And the one challenge of that is normally the Court of Appeals is dealing with a trial court record. We are dealing with we're an error correcting court. We're looking at transcripts. We're looking at those details. What the benefit that the Supreme Court gets when the Court of Appeals looks at a case first is that we've really done a lot of the spade work. And I think it narrows the work that the Supreme Court needs to do.
All right, Judge Dietz.
Yeah, I think there's one compelling reason for the Supreme Court to step in and take a case out of the hands of the Court of Appeals, and that's when it's a case that clearly would be one that the Supreme Court ultimately will hear. So it's a case that once decided by the Court of Appeals would satisfy the criteria for the Supreme Court to take it, and there's some very strong reason why the case needs to be decided and reach final judgment quickly. And I think that's the only reason. And so one thing I'll disagree a bit with Judge Inman about is I think our current Supreme Court is taking cases from the Court of Appeals at an unprecedented rate and not the kinds of cases that I just described that need to be heard. And in fact, I don't think the court is taking them because they're not busy enough. There are a lot of very important cases in the Court of Appeals where we have conflicts in our case law that we can't resolve because only the Supreme Court, when we have these conflicting judgments, can step in and say, here's what the law should be. And those cases, I think, are important and should be resolved. They're not taking those cases. And we have many cases, for example, where there's criminal defendants, and we've upheld a criminal judgment. So this is someone who's been deprived of their liberty, and they're in prison. And they have petitioned the Supreme Court to hear the case. And the Supreme Court is not expediting those cases where it's possible that somebody is in prison and should not be in prison and had their liberty taken away by the state. And instead, they've focused on taking cases that seem to have a political dimension. And I think that's part of what's harming the integrity of our courts right now is that that appears to be political. And again, part of the message that I have for the public is I'm going to steer our Supreme Court away from that kind of thing and get it back to its core role of creating a stable body of jurisprudence so that people can know the law and they can resolve their legal disputes fairly. And I think when we look at it from that context, it should be a very, very rare scenario where the Supreme Court would ever reach down and take a case away from the Court of Appeals.
Mr. Allen.
I agree with Judge Dietz. I would add that as I've gone around the state campaigning, I have heard many people talk about the way the Supreme Court has been pulling up cases when there's not a clear reason to do so. And many people have suggested that action, or have said that action appears to be related to the fact that we have an election coming up. And I think that's unfortunate. I think it makes the court look more like a political body than a court of law.
And Justice Ervin.
Well, I'm somewhat handicapped in answering this question by the Code of Judicial Conduct. It prohibits me from commenting upon cases that are pending before the court. And so my response to this question has to be considerably circumscribed. I would say as a general matter, when I have to vote on whether to allow bypass petitions, the things that come into my mind are the things that are set out in the statute. After all, there is a statute that specifies circumstances under when this can and cannot be done. And the factors that I think of and that I think are set forth in the statute are some of the ones that my colleagues down the table have alluded to in the past. Is this an important case? Is this one that will have substantial public importance? Secondly, is this a case that is likely to wind up in front of the Supreme Court anyway? Thirdly, is there a need for expedition? Now, I would agree that generally speaking, justice delayed is justice denied, and that there's always things that the courts can do to move cases along more rapidly than they do. But there are cases that clearly call for resolution in an expeditious fashion. And I think those are the types of cases that ought to be the subject of allowed bypass motions. I don't think I can comment any further with respect to the other statements that have been made, except that I would challenge anyone to look at my record, and you can find instances in which I have voted in ways that would not be perceived to be what one would expect given my political position. You can take a look at that, see what you think, and you can make your own evaluation about how I have conducted myself as a member of the Supreme Court.
All right, I'm going to try to work in one more question before we go to our closing statement, so try to keep these responses concise. I know you are lawyers, but let's try. All right, so is there a provision of the North Carolina Constitution which you believe is more protective than the equivalent federal provision? And you don't have to actually think it should be more protective, but just give me an example of a protection of a right or procedure in the North Carolina Constitution that is stronger than the comparable federal protection. Start with Justice Ervin.
Well, there are a number of instances in which the court has done exactly that. So that's not really a question of, what I think. It's a question of what the court has held. Historically, if you look at some of the court's substantive due process cases involving economic issues, there are suggestions that the degree of protection provided under the law of the land clause may be more substantial than that provided under substantive due process at the federal level. Another example in the criminal context is the decision that the court made a generation ago to decline to hold under Article 1, Section 20 of the North Carolina Constitution that the good faith exception to the exclusionary rule applied. The court specifically held that in North Carolina it did not, therefore providing greater protection against unlawful searches and seizures than was provided under federal law. So there are specific instances in which that's already been done.
Mr. Allen.
We have certainly some rights in our state constitution that don't even appear in the federal constitution. And we have recently, or the people of this, I can't comment probably any further on that because it concerns some issues that are going to probably come before the court in the near future. So I'll leave it at that. Thanks.
Okay. Judge Dietz.
Yeah, I think in law school, we all study the Lochner era and the idea that there were these protections of economic liberty in the Due Process Clause that have been reduced to what we now call just rational basis. You know, is it rational what the government was doing? And we do have much stronger protections in the North Carolina Constitution in that similar realm of economic liberty. It comes not just from the Law of the Land Clause, but another bundle of rights that I know you all heard some about earlier in a previous segment, the Fruits of Their Own Labor Clause, the Monopolies Clause, the Exclusive Emoluments Clause, the Just and Equitable Tax Clause. So I think what's remarkable about our state constitution is how our framers both use some of the similar language that's in the U.S. Constitution, but also have these wonderful special rights that are, you know, sort of part of the spirit of North Carolina that only we have here in our state.
Judge Inman.
The Fruits of Their Labor Clause is particularly interesting to me because I worked on authored an opinion in Mole versus the City of Durham recently about that. And interestingly, the Fruits of Their Labor Clause was added into our Constitution in 1868. And if you look at legislative history, if you look at what the framers were talking about, that was a rare time in North Carolina in Reconstruction when the legislature voted to put to the people to amend the Constitution to make sure that formerly enslaved people knew that they could not be required to work for free and that no one would expect that a formerly enslaved person would work for free. But that indeed has given rise to these economic rights. And it's important that we look at provisions like, and then when you consider it with other provisions in the state constitution, it's important not to say this is going to be in lockstep with what the federal constitution would do in these cases, because it's under the North Carolina state constitution.
Well, thank you very much for your audience submissions, and we are now ready to proceed to closing statements, and we will start with you, Judge Inman.
I am so lucky to be sitting right next to you.
I hear that all the time.
Well, in closing, I will just say I wish that we had more time together because this is such an impressive group, and I know that you all understand the issues in these judicial elections more than many, many other people. I have enjoyed, it's the privilege of my life to have served as a Superior Court judge and to serve on the North Carolina Court of Appeals. I'm at the end of my term, and I believe that my experience has prepared me to fairly and impartially consider the hardest and the most hard-fought cases that are decided by our Supreme Court. Partisan politics does threaten the independence of our judiciary and the public's perception of that. And I'm going back to the Board of Education case that I talked about. That was a split decision from the Court of Appeals. I don't remember the entire panel, but I think Judge John Tyson, who's here, dissented from my majority opinion, and it went across the street to the Supreme Court. There was a split decision, and in the dissent were Chief Justice Martin and Justice Robin Hudson. We were dividing not along party lines on very, very important constitutional cases. And it's very troubling to me when we see that the Supreme Court, especially in the year of 2021, had so many cases of all matters that weren't even political, where you had a 4-3 decision. I think that a pattern of judges and justices voting together in lockstep suggests that they are not acting as independently as they need to be. I have a record of collaborating with my colleagues, of dissenting when I believe that they have misstated the law. I think that's an important role. And if you look at my record, I think you will see that I am prepared to collaborate but also to honestly discuss differences and to help make decisions that find common ground narrowly rather than making radical change, so that we can have the stability that our democracy requires of our Supreme Court. Thank you.
Judge Dietz.
It's been one of the honors of my life to serve for the last 8 years on the Court of Appeals, and I am so proud of North Carolina's justice system and so proud of all the people that work in our court system. And I truly believe that North Carolina is a model for how the rule of law can keep a society safe and help everyone grow and prosper together. And I think throughout our history, the North Carolina Supreme Court has been a central part of that success. And I'm running for Supreme Court because I want to keep it that way. And I think our Supreme Court needs leaders who can reassure the public that the judicial branch, the courts are independent, that the courts are not involved in politics, and that the judge's role is to defend our constitutional rights, to protect the rule of law, and to help people resolve their legal disputes fairly. And that's it. And I can be that leader for the North Carolina Supreme Court, and that's why I'm running. And I would just ask you all, when you go to vote in November, to vote for Judge Richard Dietz for Supreme Court. And thank you all, and thank you for believing in me in this journey to our state's highest court.
Mr. Allen.
One of the first questions that we heard involved Article 1, Section 5, a frequent recurrence to fundamental principles is absolutely necessary to preserve the blessings of liberty. I want to focus for just a moment on that word necessary. That means if you don't do it, we lose our liberty. One of the fundamental principles that our Constitution lays out is separation of powers. Why is that so vital? Well, more than any other branch of government, the judiciary depends for its authority on the public trust. If the people don't believe, if we get to the point where a critical mass of the public has no longer believes that our courts function as courts of law and instead function as political bodies, as super legislatures, we'll lose our justice system. I'm running because I don't want that to happen. I agree that we have a model system that was given to us by our founders and preserved by so many judges and lawyers who've gone before us, but there's no guarantee that we keep that. We have to renew our commitment to those values with every generation. And so I'm running for the North Carolina Supreme Court to do what I can to increase the public's faith in our state's highest court as a body where decisions, especially in politically charged cases, are being made by justices who are basing their decisions on the law and the facts and leaving their personal preferences at the door. I ask for your support in this race. Again, I'm Trey Allen, and thank you so much for taking your time to listen to us today.
Justice Ervin.
And lastly, I want to echo Mr. Allen and my colleagues in thanking you for your attention this evening. These are very important races. Lawyers have outsized influence in these races, as you all know, because many people talk to you about what these races are, and so I appreciate you paying attention. I've talked a lot about my record because alone among the folks up here, I've got one on both courts. I think if you look at my record, you will see that I try to do what I described earlier. You can see analyses of voting patterns. I think if you look at those, you will see that I do not hesitate to take any particular party's side in a particular case because I think that party is correct. I think that's what the law requires, and therefore I do it. I've done that even in what can be described as politically charged cases on several different occasions. Ultimately, the success of a court depends upon the perception of the fairness and the impartiality of that court. All of us that are on this podium have been through a fairly lengthy campaign process already. I think most of us will probably be happy when it's over in a couple of months. But I can point to you as at least one piece of evidence that I can do the job fairly and impartially. I have the endorsement of both the Advocates for Justice and the Association of Defense Attorneys. These are folks who litigate against each other. But both of them have concluded that my record is one that they can have confidence in. I ask you to have confidence in that record as well. Again, I would appreciate very much having your support. Thank you for the attention that you've paid. Thank you for your interest in this forum. Mr. Moderator, thank you for your participation in it as well, even though we didn't talk about sanitation apparently as much as you would have liked. And again, it's been a great time to spend with you. Thank you very much.
All right, so I want to thank all of our panelists for sharing their ideas and thoughts with us, and let's give them all a round of applause. Now I'm going to relinquish the lectern to Ashley Terrazas, who is the head of the Triangle Chapter of the Federalist Society, and she is going to finish us up, I think. Last minute substitution.
That's it. Hello, everyone. I just wanted to, again, thank the panelists, thank the moderators. Without them, this would not have come together. I especially want to thank Ashley. That's why she should be on the stage. She put the team on her back here, I'll say that. But also the board members from all the chapters across the state did a great job. I want to thank our law student volunteers. I see several of them around the room. They did a great job. Couldn't happen without them. The very important news you want to hear about is they are setting up the bar, but we have to exit the room for 10 minutes while they get that set up. So I will see y'all back in here. I want y'all to mingle, get to know everyone. I look forward to it. Thank you.